evening, everyone. Welcome to 42BR's virtual pupillage event. We're really happy that you've been able to join us this evening. And whether you're listening to this live or you're listening after the event, we're really happy that you've been able to join us. So, as you will have seen from the programme this evening, what we're hoping to do is to give you an insight into what life is like at 42 Bedford Road. So, you're going to be hearing from a range of different speakers who are at different levels of experience, and they're just going to share their thoughts about what life is like as a barrister in chambers. So we're going to make a start without further ado by hearing from one of our newest tenants, Max Montgomery. He has recently completed his pupillage in chambers and is in the first year of his practice, and he's going to tell you a little bit about what life is like at the very junior end of chambers. So Max, over to you.
Thank you, Safia. Hello, everyone. Yes, as Safia says, I am one of the very newest members of Chambers. So I finished pupillage in October. So I'll give you a bit of an overview of what pupillage looked like for me and then the sort of transition and what my practice looks like now at this very early stage. So pupillage year obviously split into first six and second six. In first six, there were two seats. So I had one family seat with Philip McCormack, who does pretty much all public children work. And then my second seat was with Safia, doing employment work. So in that first seat, I spent quite a lot of time out in Kent, where Philip has quite a lot of practice in Kent, and so I would be out and about in court every day with him. And then also within that 3 months, I was getting opportunities to go and see the other family work that's done within chambers. So I went and saw some financial work, saw some private children work, and so on. And a lot of it was watching and learning in court, and then also bits of written work and lots of research as well on the side. Then that second seat with Safia focused on employment, and Safia had I think it was a 17-day discrimination case during those 3 months. So most of it really was taken up by that, which was really interesting. And then otherwise, I quite a lot of time in chambers. Quite a lot of the employment work is remote, so I got to be in chambers a lot, which is great to meet lots of other members of chambers and pick up bits of research and so on from them, and see some of the other civil work that is done. There was then the sort of transition to second six was sort of, I'd say, as smooth as it can be. You do sort of get pushed off a cliff, I think, when you're sent into court, no matter what chambers you're at. But it was reasonably smooth in the 2 weeks leading up to that. Myself and my co-pupil were sent off with the very junior members of chambers and saw some of the stuff that we would be doing when we stood up in court, and that was really helpful to sort of demystify the whole process. And obviously, the sort of, I wasn't going straight into a 17-day discrimination case, so to see the sort of thing that I would really be doing was really helpful. Second six then came along. I had one supervisor throughout my second six, which was really good because it was helpful just to have a kind of consistent presence that I could lean on. It was quite a different relationship where we weren't necessarily in daily contact. We probably were at the start when I had very many questions. But as time went on, that was just a sort of relationship where my supervisor, who was Matthew McDermott, was there essentially on the end of the phone when I needed him. I was sort of getting on with it and developing my own practice at that stage. I was in court initially a few times a week, up to having a pretty full diary pretty quickly, which was great. Lots of the sort of classic stuff at the junior end in terms of civil. I was doing some RTA type stuff, doing some possession hearings, doing preliminary hearings in employment matters. Also on the family side, doing a lot of directions hearings and non-molestation applications and those sort of things. And really was in court every day after a month or so. That being said, I was able to put paper stays in my diary and so on when I needed them. And so I'm still learning to manage my practice, and go along that way. Um, there was loads of support from obviously my supervisor, but also we were put in various WhatsApp groups, particularly with the junior members of chambers, and they were used pretty regularly, certainly at the start, in sort of panic calls before going into court when issues arose. So that was all really helpful, and it's remarkable how quickly you start to feel like you're being a barrister and you're going to court every day, and it's all very strange and very exciting. Um, there was then a pretty smooth transition to tenancy. To be honest, it's not a pupillage where there is a sort of formal assessment at the end, and then you do or don't get tenancy on the basis of that. It's I suspect we'll get into it, but it's more informally assessed as you go. You then find out over summer whether you kept on, and at that point, there was no great transition, to be honest, from the last day of pupillage to the first day of tenancy. I was doing similar sorts of cases, and it flowed quite nicely. Those cases have been gradually, same sort of stuff as what I mentioned earlier, but obviously the length of the cases are growing, and the complexity as well. And it's I feel like my practice is developing at a nice pace. The highlight so far was probably a 2-week inquest that I got to do with Richard Furness. I was junior counsel to the inquest into the death of police officer Ratana, and there's a police officer who was killed in Croydon a few years ago. And that was a really interesting couple of weeks doing that, and lots of media attention and all that sort of thing around the case, which I hadn't seen before, and it was really interesting to be a part of. So there's been great opportunities to do some lead work in that respect, and then also developing my own practice. I think probably the most straightforward way of telling you what my practice looks like is to describe my week this week. And I was meant to be in Birmingham for a 3-day employment unfair dismissal case. That settled last week. So my week has been a bit busy. But on Monday, I had 2 witness statements to draft for an employment case. On yesterday, I was doing a possession hearing in West London. Then this morning, I had an application to set aside a judgment in a property matter. Then at 4 o'clock today, I had a conference with a client in advance of a 4-day fact-finding hearing in a family case in a couple of weeks. And then I had to very quickly finish off an application that I was drafting. I've got 2 possession hearings tomorrow, and on Friday, I've got a 1-day final hearing in a family matter. So really varied, and next week, similarly varied. So really busy, really enjoying it, and that's about where I am now.
Fantastic. Thanks very much, Max. So hopefully that's given you an insight into the early stages of tenancy at 42BR. If you have any questions for Max, we're going to deal with all the questions towards the end of the session once we've heard from all the speakers. But please do use the Q&A function in Zoom. I think some of you have managed to find it already and have sent over some questions, for which thank you. We will make sure that we get to all of the questions that you ask at the end. So if you do think of anything that you want to ask any of our speakers, please do pop questions into the Q&A box. Now, we are going to be hearing from some more senior members of Chambers about their work as senior practitioners in Chambers. We've got a couple of people who are due to join us, but they're not quite able to join us as yet. Such is life at the bar. You can plan what you think your day or your week is going to look like, but it doesn't always pan out, as Max has already explained. And so we should have a couple of people joining us fairly shortly. But before that, we're going to be hearing from Marcia Hyde. She is a specialist family practitioner, but she also practices in animal welfare law, and that's a fairly new group within Chambers. We've had lots of questions and queries when we've attended events about this group, and so we thought it was really important that we explained through Marcia what exactly this group does and how it all works. So Marcia, please explain to everyone more about animal welfare law, please.
Thank you, Safia. Well, first of all, can I say my main tip to you is don't arrange anything if you're at the bar between a Monday and a Friday, because you'll have to cancel if you want to go out in the evening, because you'll have papers, you'll be running from court, and that's life, as you can see. Animal welfare group. I was asked by Safia to really explain how it had come about we'd set up the group in Chambers. And it was a coincidence of events, really, and thinking. I moved back to 42 Bedford Row about 4 or 5 years ago at a time when I was thinking I wanted to expand my practice, and particularly to start doing something law-wise about animal welfare, which has always been something close to my heart, as it were. And the reason it was a good idea to do it at 42 is because 42 has a combined civil and family side of Chambers. So we have a lot of expertise in a lot of different areas of law. And for a reason I'll come on to explain in a moment, that's crucial if you want to practice or do animal welfare work. And I think combined with that coincidence, as it were, was a growing sensibility among everybody, I think, on the planet about, probably caused partly by COVID, but also by the climate emergency, about how important animals are to humans and vice versa, and how biodiversity is so important and crucial to all of us. And I think sensibilities about that have changed quite dramatically over the last 5 or 6 years. So it was a kind of constellation of factors which led me to think, let's set up a group in Chambers with people who are interested in promoting animal welfare and practicing law, and how could you combine those things? I have to say, 42 Bedford Row is a very supportive set of chambers, very helpful, very, very forward-looking, and we're really supportive in doing what was actually quite a progressive move to setting up this group, because there are not many groups at the bar like this. So that's how we set things up. The main point I would like you all to take away from this event, and no doubt you'll have some questions about it, is that nobody ever has a practice which is just purely animal welfare or animal protection law, because that's not how it works. Animal welfare is to be found, and law is to be found in every other aspect of law. And so if you come to 42 or wherever you go to practice law, which I hope you all do, you will have your own specialism. And within that specialism, there will always be an animal welfare issue. And so if we look at 42, we've got about, I think, 7 practice areas now. And just to give you some examples about how animal welfare works and how the animal welfare group works, there are about 15 of us now, and we're all from different specialisms. But we all come together on an idea of how do we promote animal welfare within our practices? What can we do? Where are the areas of law within our practice areas, excuse me, that we can promote and protect animals as well as humans? So, for example, I'm a family law practitioner. I've been practicing family law for about 30 years. Within my practice, I specialise in child protection, and within that, I deal with a lot of domestic abuse. Within domestic abuse, as some of you will probably already know, is controlling and coercive behaviours as a form of domestic abuse. And one of the things that there is now a lot of research on is how the animal, or the pet, or the companion animal as they're now being called, are used by an abuser to control a victim. And that is happening increasingly. And within that area, there's a really very strong connection between human violence and animal violence. There's high correlation. So if there is animal violence in a family, then that is a red flag to tell you there is going to be other types of abuse and violence within that family. There's a massive correlation there. And so highlighting that link in family law both protects humans, but also protects and helps protect animals through, publicising what is happening. So that's what happens in family law. But in the other practice areas, for example, employment law, one of our members who's in the group, he was dealing with emotional support animals and whether or not it was right or wrong for an employee to have an animal as an emotional support animal. What was hilarious about the case was that it was a squirrel, I think, on an aeroplane, which was like, but so there are all sorts of areas. The other thing about employment is veganism is becoming a really major issue, and whether or not companies are have to provide vegan meals in canteens and things like that. So that's an example from employment law. An example from housing law, which is another one of 42's specialism, is the new rent bill. I'm not even sure if don't know what's happening to that Rent Act, what's happening to it yet. But one of the provisions of that is that tenants are allowed to have pets, and it will be a statutory right for a tenant to have a pet. And that is good for humans, but it's also good for animals because it gets them out of sanctuaries and it gives them a home and a place to live. Regulation law, a lot of regulation law is about farming regulations, whether or not the regulations have been breached, etc. That's a big area of law. There's also, of course, prosecutions under the Animal Welfare Act itself. We do a lot of that, acting for the RSPCA. Even in business law, professional negligence in respect of vets and their practices. Even personal injury law. I think one of our members did an advice on whether or not seeing or observing abuse of an animal would count as emotional damage, which you could get damages for. The other big area is public law, judicial review. So, for example, last year, there were 2 big judicial review cases to do with animals. One of them was in respect of chicken farms, and the other one was in respect of animal testing for cosmetics. Excuse me. So that's the wide range of issues and types of law that are involved in animal welfare. So it's not having an animal welfare practice, it's incorporating animal welfare within whatever practice you're doing. And I think that's my message. I think that's the thing that most people need to or want to understand.
Thank you very much. That's really interesting. If anyone does have any questions about what Marcia has explained, you are very welcome to ask using the Q&A function within Zoom. I can already see some questions coming in, so we will come to those, as I said earlier, towards the end of the session. As you will have seen, we have Tom Wood, who's been able to join us. So Tom is a senior practitioner in Chambers. He specialises in personal injury and clinical negligence work. And he's going to give you an insight really into what life might look like as a tenant in Chambers sometime after you have qualified and completed your pupillage. So Tom, over to you.
Thank you, Safia. Good evening, everybody. So I didn't do my pupillage at 42BR. I started off somewhere else and then came along a couple of years later. So I'd already started the process, as Max now is, of doing everything. I'd already gone down that path. So as a senior kind of personal injury clinical negligence practitioner, I still think there'd be quite a large variety amongst practitioners as to what their practice looked like. In terms of my practice, it involves a great deal of advisory work, conferences with clients, drafting pleadings, preliminary hearings, applications, settlement meetings, not many trials. So in terms of my diary, it is still changeable. I think some people, when they reach a certain level of seniority, especially when you're undertaking a large number of trials, your diary becomes a bit more settled because things go in your diary a long time in advance, and they're unlikely to change. That actually isn't really the case for me. I still have things coming in at relatively short notice. So my practice, it changes quite a lot because applications will come in at short notice. Conferences with experts will be required because a report comes in that needs some amendment. You might have to have an urgent settlement meeting because something has changed in a particular case. So actually my diary is still pretty fluid and actually fills up at relatively short notice. So I'll be busy for the next 3 or 4 weeks in my diary. Beyond that, I might have some trials booked in because they may well fight. But in general, things tend to go into my diary at relatively short notice. Even, as I said, other people at my level of call might actually have a completely different practice, even within the same practice area. So Max earlier referred to an inquest he was involved with. If you end up undertaking inquests as part of your personal injury and clinical negligence practice, which is kind of an add-on, which many people do, then you will obviously be in court or in the inquest a lot more, especially if you end up undertaking public inquiries, which can obviously end up going on for months, if not years, where you're in essence not necessarily in court, but you're in the inquest or in the inquiry, which is tantamount to the same thing pretty much every day. Equally, you might end up having a defendant-based practice. Mine is predominantly claimant-based. And if you've got a defendant-based practice where your particular solicitors accuse claimants of being dishonest, then you'll have a far more court-based practice where you're in trial up and down the country accusing claimants, bringing claims which aren't true. So that's, I think, why I like life at the bar. Even within a particular set of chambers, even within a particular practice area, there are so many different areas that you can focus on that lead you to a very different lifestyle in terms of the extent you're in court, the extent that you're travelling, the extent that you're involved directly with members of the public, or whether you're mainly involved just with your instructing solicitor, whether you have a practice that involves experts, whether they're medical experts or otherwise. So that's the main focus that I wanted to get across, that life at the bar isn't one size fits all. In fact, being a lawyer in general, I think, allows you to pretty much have the job that you want it to be. And the main thing I think I would say about my particular practice, given that it is very much paperwork based in terms of drafting advices, drafting pleadings, and so on, is it's very flexible. If you want, you can get up early, do all your work by lunchtime, take the afternoon off. Equally, you could get up late, work all afternoon, work all evening, and take the morning off, because there isn't that same urgency that it has to be done tomorrow. You have to organise your own paperwork into the time that needs to be done and the time that you need to do it. You need to work out how much work you're capable of doing. You can't take on too much because then you disappoint people. And ultimately, you have to remember that each individual barrister in a set of chambers, whether it's 42BR or anywhere else, it is a one-man self-employed business. And that you have to build up your own practice with your own firms of solicitors and individual solicitors, and no one cares about your business more than you do. And so that's, I think, the thing that I never really understood when I started out my career at the bar, that actually you have to think of yourself in that way and work through that. And someone told me, probably at an event very similar to this, there are some great barristers out there who have mediocre practices, and there are some mediocre barristers out there who have great practices, because actually those are the barristers that are really good at getting the top quality work for themselves, irrespective of perhaps how great they are when they get it. But anyway, that was what I just wanted to finish on, and I'm sorry about the technical issues, but I think we've now resolved those.
No, don't worry at all. Thank you so much, Tom. That's really helpful. I can see lots of questions coming in. If you have any questions at all, please do use the Q&A function within Zoom, which you'll find at the bottom of your screen. Lots of questions, as I say, have come through already. I'm going to talk a little bit now in my capacity as head of pupillage about the pupillage process in chambers, the application process in particular, which is, I know, what most of you are particularly interested to hear about. And I can see a lot of the questions that have come through already actually deal with that process and ask some questions, and hopefully I can answer a number of those questions as I go through. So let's start at the very beginning. Obviously, the application window is open, and the fact that you're here means that you're probably interested in a pupillage at 42BR, which is fantastic. I know a lot of you have been asking questions about what sort of areas should you show an interest in, or should you have some experience of, and is it going to count against you if you have experience of some areas that chambers work within and not others? The very simple answer to that question is we don't expect people who are applying to 42BR to have experience of every single area that we do. That would pretty much be impossible, to be perfectly honest. But what we are keen to look for are people who have experience and an understanding of some of the areas, even if it's only one, but something that Chambers does, and has an interest in undertaking work in other areas that Chambers practice in. So if you are interested in one area of law and one area of law only, then we're probably not the right set for you. You might want to be looking for a set that only practices in the area that you're interested in. But if you are somebody who has some experience of a variety of civil areas, or family, or a bit of both, and if you're someone who actually would prefer to be at a set where you can do a variety of different type of work, then we would absolutely love to hear from you. And we're not going to hold it against you, and I know a number of you are worried about this, that you don't have experience in all the different areas that we do. So we are looking for people who have an interest in Chambers work. I'm often asked, well, what are the 3 key things that you are looking for in a pupil? And the simple answer is, it's not as formulaic as that. We don't operate a system where we are looking for 3 things, 5 things, whatever number it might be. And if you can show us those things, then that's a good application. And if you don't, then we're not going to consider your application further. It simply doesn't work like that. What we're looking for are people who can demonstrate that they have, first of all, an understanding of what the profession is, what is life like as a barrister, and attending events like this is obviously really helpful in explaining that to you. But we want people who have some understanding of what a career at the bar looks like. We're looking for people who obviously have some sort of experience of it. So have you conducted many pupillages? Have you attended events, so that you can demonstrate that you understand what life at the bar actually looks like? We are obviously also, as I said a moment ago, looking for people who have an interest in the areas of work that we do. And then over and above that, we're looking for people who essentially can interact with a wide variety of different types of people. Now, what do I mean by that, and why is that important? Well, in very simple terms, if you look at the different types of work that we do, you, as an individual who joins Chambers, will be somebody who has to engage with, potentially, senior individuals in an organisation, right down to the individual who perhaps is in a very vulnerable position, who's come to court to seek your assistance, who's never experienced court before, and who might need your help. And of course, you also have to engage with your professional clients, so solicitors, for example. And each of those groups requires a different skill set to be able to speak to them, to be able to gain their trust fairly quickly, and to be able to then act on their behalf to the best of your ability. And so we're really keen to talk to people who can demonstrate to us that whichever type of situation they're put in, they're able to then interact with different people and make the best of that situation in whatever those circumstances might be. And that's not something that you can just distill into 3 or 5 words. It's really about what kind of person are you and how do you demonstrate that on paper. Now, obviously, your application form is a form of written advocacy. So we're also looking for people who will show us through their form that they've spent time on it. If you are going to have an application form with lots of spelling and grammar mistakes, then that is going to be a difficulty. It's going to count against you, because what it shows us is that you probably haven't checked it as carefully as you could have done. And I do suggest, when you are filling in these forms, that you don't leave it to the last minute, tempting as it might be, and that once you have drafted your answers to the questions on the form, or indeed every part of it, that you do ask someone else to cast an eye over it, because sometimes it's very easy not to notice your own mistakes, and sometimes it's helpful for someone else to have a look through and give you some feedback on it. So it's important to try and put that effort into it, because it does show, I'll be very honest, and it does have an impact on how we view your application as well. So in very simple terms, that's what we're really looking for. How can you show us those things? Well, really, it's about telling us about you, kind of person you are. There are obviously questions on the form that we've asked you to complete, but we're trying to get a sense of you as a person, and we're trying to get a sense of what you bring to Chambers. So as a very simple example, and I say this at all these kinds of events, there is a section in the form where obviously you can fill out your experiences. So you can put down your mini pupilages, your other work that you might have done. And it's very common in that section, particularly when people are talking about things like mini pupilages, for people simply to list a few things that they might have done. So they might say, attended an event with Chambers, attended this type of hearing at this type of court, saw this. Now that's fine. You told me what you've done. But that doesn't necessarily tell me what you actually gained, what you benefited, what you learned from that. And so it's a really good opportunity in that section of the form for you to set out what it is that you took from that experience, so that we can understand, when we are looking at your form, how you actually felt that those experiences helped you in whether it's making a choice about what you want to do or particular areas that you enjoy, or even just to show us that you have an understanding of what life at the bar actually looks like. So do take some time to look at those parts of the form and tell us a bit more detail about those particular experiences or events, so that we can actually see more about how you interact with us through that particular form. I know it's not the most exciting form in the world, and that's the reason why we have a 2-stage interview process. So once we've reviewed all the application forms, what we do is we will create a long list of individuals that we want to interview at round 1. Now, our round 1 interview is a fairly short interview, and it's really about getting to know the person behind the form. Because, as I've said, the forms are not the greatest or the easiest to navigate. They're also perhaps a little bit dry. And so it's nice to actually meet the person who's written that form, match them up with the form itself, and get to know you a little bit more. So we will invite a number of people to round 1, and then, having met those individuals, we will then select a shortlist for round 2. And that's going to be a much longer interview. We will give you a question to think about in advance of that interview that we will discuss within the interview. We also like to ask some ethical questions so that we can really get you thinking and see how you think through tricky situations. And obviously then there'll be some more general questions as well. So that's a sort of overview of the process that we use in chambers. I think there have been various different questions about what the interview process looks like, and hopefully those have been covered. We've had a question just linking to what I've said about seats, practice areas for pupillage and whether or not they are fixed. And that's a really good question. So because, as you've seen, we operate in a variety of different areas, if you have an interest in a particular area or more than one area of chambers work, we do try where possible to make sure that we can accommodate that interest. So if you turned up and said, well, actually, I'm really interested in doing personal injury work, or I'm really interested in family work, then we will try and make sure that we can allocate you a supervisor who does that kind of work. Obviously, it's not always possible. It really depends on the situation and whether supervisors are available and what work they're doing, etc., etc. But as much as we possibly can, and certainly in the last couple of years, we have managed to make sure that when pupils do have an interest in a particular area, we will be able to accommodate that. So I'm going to go and see. We've just had another question about numbers of individuals. And the question was whether we had a set number of individuals who we invite for first and second round interviews. Not exactly is a very simple answer. It does depend. Obviously, we have a minimum that we're looking for, so a minimum number of places that we want to fill. But if we have some really good applications and we're struggling to decide between them, then it's not uncommon for us to invite a few more than we might ideally want, and we will make sure that we can make time to interview a few more people, because we want to make sure, as you can imagine, that we can get the best possible candidates who are best right for chambers and who want to come to chambers. So we will try and work around those situations as they occur. All right, I'm going to go through some of the other questions now. Let me just go through these questions. They're not all for me. So Max, Marcia, I think there are some for you that I'm going to be sharing as well. Max, a question is coming through for you. Why did you choose 42BR for your pupillage?
I think the simple answer is that I didn't know what practice area I want to specialise in. Still don't know what practice area I want to specialise in. I don't think I will anytime particularly soon, and I don't really know how one could at this stage. And so going somewhere that had as much variety as 42 did was really was really attractive to me, and that was kind of the main thing that encouraged an application there. And I've got exactly what I wanted out of that. I sort of outlined quite how much variety there is in my practice at the minute, and I think I'm really reaping the benefits of that, which is great.
Fantastic. Marcia, lots of questions for you about the animal welfare group, so I'll go through a few now and then perhaps we'll come back to some more later. A question, it says, I'm really interested in JR for animal welfare. Is anyone in the animal welfare group considering becoming involved with the possible JR for the XL bully ban? I'm not sure if you can give us an exact answer to that, but is there anything that you wanted to say about JR for animal welfare?
Well, certainly, I know that there is, shall we say, a move to try and JR the that ban. I know we had a group in Chambers, a seminar in Chambers quite recently, where someone involved in dogs and animals was looking at instigating a JR. So I'm sure that is going to come, and I'm sure they will be in contact with us about that. It's something which I know it's a difficult area, but it is an area that a lot of animal welfare groups are looking at to see whether or not it's fair, because for most, I think, animal welfare people, that it's not the dog that's the problem, it's the owner that's the problem. And I think that's the perspective that we come from. So you ban the dog, you kill the dog, you put the dog down, but actually there was nothing wrong with the dog. It was just that it was being used by a human in a way that they shouldn't have been. So yes, I think there will be a JR coming up on that. And so, watch this space, as it were.
Some more questions for you. Somebody's asked, what practice area would animal smuggling fall under, and would that be criminal law?
Well, that's quite a complex question, actually, because it depends what animal it is, and it depends where it's coming from. For some animals, for example, that you import, you need a license for. So if you haven't got a license, then that's a breach of regulations, but it also can be a criminal offence. If you import an animal, for example, which is banned, then that's a criminal offence. So it depends really what the animal is, and it depends where it's coming from. For example, some animals you can import from the EU with a license, but you can't import from anywhere else. There's a different system. And that's one of the things about an issue like smuggling. It's just not one area of law. It's a different area of law depending on what animal you're looking at. So wildlife importation, birds, etc., reptiles can be different from trying to import a banned animal like a lion or something like that. So it depends what animal it is and where it is, and what the regulations are and what the acts which might specifically cover a type of animal will point you to the right area of law. So it's not straightforward.
Thank you, Marcia. One more. Can you tell us about the benefits you get as a practitioner from being part of the animal welfare group?
Well, I'm not sure if this is about other people in the group or me personally in the group, this question. I think everybody in the group enjoys discussing and exchanging information from, and it goes back to what Max and the others are saying about being part of a multidisciplinary set. I think what's good about it is we exchange ideas and cases and get involved in events together from our different areas. And it opens up your mind, actually, to how one subject or topic can be looked at in a different way. And that's always useful for a lawyer, I think. And from a personal level, I think it gives people a lot of satisfaction to do something that they are really motivated and care about.
Fantastic. Lots more questions coming in about pupillage, so let me go through some of those. I've been asked whether or not first round interviews are remote or in person. So the simple answer is, with first round interviews, if you are able to come to chambers, then that's obviously ideal. But if you are not for any reason, then we can accommodate first round interviews remotely. With second round interviews, it's a little bit more difficult because there is inevitably a difference between a remote interview and an in-person interview. And we think it's actually probably in your interest to be able to attend in person, particularly for a second round interview. Although if there are particular reasons why that isn't possible in the circumstances, then we can work through those with you. So if there are particular reasons why you don't feel that you could attend, particularly a first round interview in person, please don't let that stop you from applying, because we can make remote interviews possible for you. I've also been asked a question about non-legal work experience from mature applicants. And the question essentially is, well, would an applicant's years of corporate experience be viewed as relevant to chambers practice areas? Let me be very clear, there's absolutely no issue whatsoever with individuals who are applying having had careers doing other things before coming to the bar. It's actually not uncommon, and we have a number of members of chambers who fall into that category. And all I would say is, as long as you can demonstrate from your previous experiences what skills you think that you have gained that you think would be transferable to a career at the bar, there's absolutely no issue whatsoever. Obviously, in the same way as any candidate would, we need to understand or be clear that you have an understanding of what a career at the bar looks like. And that you would be coming in obviously at the junior end, but it's not an issue whatsoever. And really, it's about demonstrating to us what skills you think that you have from whatever experiences you've gained. And to be honest, that applies whether you're a mature candidate or not. What you think you can bring to chambers and what skills you think that you have that will help you to become a quote-unquote good barrister. So that's not an issue whatsoever. A very good question, which actually I should have probably dealt with earlier. The question is, do pupils compete for tenancy, or will all pupils be taken on as tenants if they meet the necessary criteria? So, we are very clear in chambers that we don't believe that pupillage should be a competitive process as against your co-pupil. We aim to take on 2 pupils every year, and our hope is that both pupils will be taken on as tenants so long as they meet our criteria by the end of their pupillage. We feel that it's really important that as a pupil in chambers, your co-pupil is a source of support for you rather than simply being somebody that you have to compete against. And actually, it's beneficial to have somebody in the same boat as you, who you can rely on to help you and give you that additional support through that process, because we acknowledge that it isn't the easiest of years. Some people refer to it as a year-long job interview, which to a certain extent it is, although hopefully it doesn't feel like that on a day-to-day basis, because certainly at 42BR we're very keen to make sure that you don't feel as a pupil that you are being constantly watched, monitored and assessed to that degree. We're hoping that you will settle into chambers, that you will really learn from everybody else, obviously, but in a way that's also collaborative, in a way that is beneficial, and in a way that you will find useful going forward. And we really do feel that it's important that your co-pupil is a positive part of that experience. And so at the end of every year, we do not consider pupils as against each other. We consider them individually, and there is always space for all our pupils at the end of their pupillage, as long as, of course, we feel that they are worthy tenants of chambers. So there is no issue whatsoever with any sort of competition against your co-pupil. We've also had a question, it says, I can see you're recruiting for 2024 and 2025. This is actually a very unusual situation, which hasn't actually happened for a very long time. But essentially, we have a situation where we are recruiting for 1 pupil to start this October, so that's 2024. Usually we are only looking for pupils to start the following year, so 2025, but for various reasons we are also looking for 1 person to start this year on this occasion. And then we are obviously running our usual recruitment round for 2 pupils in 2025. Advantages and disadvantages of applying for both years. Well, to be perfectly honest, I think that the way that we are going to be looking at this is to interview people and then see which of them could start in 2024 and make a decision based on that. So I don't think it really matters. Obviously, there'll be some people who can't start in 2024, and that's completely fine because you'll simply be considered for 2025 only. But otherwise, we would automatically just consider you for 2024 and 2025. So really, it's not an issue at all. I think another question about whether you can apply for both 2024 and 2025 on the gateway. And yes, I think as far as I'm aware, and I'll be corrected if I'm wrong, I think there's no issue whatsoever if you want to apply for both. And as I say, you'll be considered, we're going to essentially be considering people for both anyway. Marcia, a couple of more questions for you in relation to animal welfare. So one of the questions is, considering animal welfare casework spans many different practice areas, would you say it's a specialism that is built into your primary practice area over time, or would it be possible to start incorporating such cases into your practice fairly quickly?
I think it's probably the former, but I know there is, as I've explained before, we do some work for the RSPCA, which we are expanding, and we have been returning work on that actually because we need people to do it. That's a very, I think that's a very good pupillage or very junior practice area to get experience in, because it's court work and it's criminal really. It's semi-criminal. It's breach of the Animal Welfare Act. So you can incorporate things like that quite quickly. I think people will realise that you're not going to get mountains and mountains of work, because it is an add-on to your main practice. And it's about, I think it was Thomas who was talking before, it's an area where you can make yourself known, and you know, the harder you work at it because you want to do it, the more work will come to you. So I think it's a mixture, but I think very much at the beginning you concentrate on your own area of expertise that you want to practice in, for example, employment or family, and you gradually build in animal welfare work. And part of that's the part of being part of the group, because we get inquiries coming in which we pass around. Who's got the expertise to do this? Does anybody want to help to do this? So that's how I would see it.
Thank you. There are some more, but let's pause for a moment. We have a question, Tom, that I think you are probably best placed to answer. And the question is, are inquests a main practice area for chambers?
Yes, sorry, I'll stay unmuted, but with no video, just to ensure that I've got enough bandwidth. The answer is yes. We have a strong area of chambers practice, dealing not only with inquests, but also with inquiries. Certainly, personally, it's a practice area that I want to grow. I find coronial law very interesting. I find the process of inquests very interesting, so I'm always happy when I get instructed to attend an inquest, whether that's for the family or for another interested person. So I would certainly recommend that if any potential applicants are interested in inquests, that they would find that work within chambers, and we'd be delighted to have them.
Fantastic. Lots more questions about pupillage coming through. One question that I've seen is, do you allow reapplications for the following year if you are unsuccessful in obtaining pupillage? And I presume you mean unsuccessful in obtaining a successful pupillage in chambers. That's absolutely fine. At the end of the day, when you apply, say the following year, you are essentially a slightly different person to the one who applied before, because you have 1 year more experience in whatever it is that you've been doing in that time. So by all means, if you haven't been successful in getting an interview or getting pupillage in chambers before, then that's not a bar at all to applying again, and we'd love to hear from you, because as I say, it may be that that you are more successful this year than you were previously, so that's not an issue at all.
I got on my third application to chambers, if that sheds some light.
Well, there you go then. We've also had a question about how we are a progressive set of Chambers. Question says, I'd be grateful if you could expand on the ways in which 42BR is progressive. And the question also says, I'm aware that Marcia gave an example in the establishment of an animal welfare group within Chambers. So yes, of course, that's one example of the kind of thing that Chambers does. But there are so many more. I would probably bore you if I talked about all of them, but I'll just give you a few examples. So in terms of Chambers itself and applications to Chambers, we're really keen to make sure that people who come from a diverse set of different backgrounds are able to at least access the possibility of a career at the bar. So 42BR has a schools outreach program where we have events where essentially school pupils come to Chambers, get to understand a little bit more about what a career at the bar looks like, and we particularly focus those for people who are perhaps not coming from traditional backgrounds to the bar. We also have a university outreach program, which is fairly similar. We're part of the 10,000 Black Interns initiative run by the Bar Council, so we offer internships to students of Black African, Black Caribbean and or Black British heritage. We also run a funded internship scheme to engage people from a variety of different backgrounds. And this is all in addition to our mini pupilages, which we offer throughout the year. And if anyone is interested, particularly after seeing and speaking to people here in a mini pupilage, then please do go to our website and all the details will be there as to how you can apply. We also have a mentoring scheme in Chambers, and one of the things, in fact, that Chambers is particularly known for is for the fact that, particularly within our practice areas, we're really supportive of each other. And as you've heard already, at the end of the day, each individual is a self-employed person responsible for their own career trajectory to a certain extent. But that doesn't mean that we can't receive support and help and assistance from those around us. And that's something that we take really seriously. So we have a mentoring program for our more junior members. So once you've finished pupillage, where obviously you have lots of support from your pupillage supervisors, Chambers also then has a mentoring program so that junior members can have access to support from a more senior member of Chambers. And then we even have within our own practice areas lots of events, lots of support, silly things like even just making sure that we all have a means of communication. So we have WhatsApp groups for different practice areas where people can ask questions. No question is too silly on that group. Max will know that there are lots of questions that come from junior members of Chambers, and people are always really willing to help, and that's really important. And it's not something that necessarily you might find everywhere within the bar, but we think it's really important to make sure that people do feel supported, because whilst we are all self-employed, together we can then support each other, and once we provide that support to each other, we feel that's really important to be able to help Chambers as a whole and members collectively to do better as well. So those are just some of the examples that I would give you of things that we feel show that actually we are trying to progress and move forward. So again, lots more questions coming through. What role do Chambers supporting staff have in pupillage? Do you have a practice manager as a point of contact? So at the end of the day, your pupil supervisor is your primary point of contact because they're the person that you will be speaking to literally on a daily basis. They'll be the one allocating you work, and you will then have separately to that a point of contact being me if I'm not your supervisor. Since as head of pupillage, I always make sure that I check in with pupils. I have regular meetings with them to make sure that everything is going well, that they're enjoying it, that there aren't any difficulties or etc. But that doesn't mean that other support staff in Chambers don't also play a role. So obviously everybody is incredibly welcoming and friendly. So any difficulties or issues that people have, there are always people that they can go to. Once you start your second six, then obviously we make sure that pupils have meetings with our clerking team so that they can understand what that looks like, what their what they need to be aware of, what they need to do, what the clerks will be doing. And so that really helps to make sure that once people start to conduct their own work, that they actually understand that relationship between barrister and clerk, and they can start to then build that relationship as well. So we try and make sure as much as possible that those transitions are fairly smooth, and that allows people to progress and hopefully succeed. So lots of questions about 2024 and 2025. Hopefully what I've already said will help with those. A question, Marcia, perhaps if I can direct some more of the animal welfare questions coming our way to you. There are lots of them. One of the questions is, what duties are owed by local authorities in respect of animal welfare?
Well, they're many and varied, and again, it depends what animals you're talking about. So, for example, local authorities in local areas have to carry out, say, inspections of, say, chicken farms, or they have to inspect different farming premises, or they have to regulate and enforce regulations for animal transportation to abattoirs, for example. So local authorities have masses of duties there are a myriad of animal welfare regulations to do with farming, to do with local animals, to do with all sorts of manners of things, which the local authority either have to license, or they have to check, or they have to regulate. So again, it goes back to what you're looking at. Are you looking at a regulation which covers the welfare of chickens in chicken farming, or are you looking at a regulation for preventing destruction of wildlife? Are you looking at a regulation for something else? So local authorities have a lot of duties, and of course then they have a duty sometimes to, under the Animal Welfare Act, to make sure an animal is not being harmed as defined under the Animal Welfare Act. So there are a lot of duties that local authorities have, and one of the concerns in the animal welfare world, as it were, is that of course local authorities don't have money to basically enforce the legislation and the regulations that we have in place. And that is happening throughout all types of law, but it's very, very prevalent in animal welfare. And I think there's a charity who published a report on the problem of enforcement in animal welfare, and that tells you the level at which local authorities are involved and how difficult it is often to enforce the law.
Very interesting. Thank you, Marcia. So let me get through the last couple of questions, and as I'm doing so, if you think of any more, please do send them in, and we'll try and answer all of those before we come to an end. So we've had a question. As a junior, do you get experience doing work for both claimant and defendant and get the chance to specialise as time goes by if you wish to do so? So that's an interesting question. To a certain extent, as a junior, whether you end up doing work for a claimant or a defendant stroke respondent might well depend on the type of work that happens to be available at the time. So at the very junior end, it's really important to gain a really wide variety of work. So you'll be doing all sorts of different work, and that might be for both sides, depending on the nature of the work that's available. Do you get the chance to specialise as time goes on? If that's something that you want to do, then yes. Depending on how your practice develops, and if you're able to develop a practice for a particular side, as it were, then that might well be something that you can do. And it will really depend on the work that you get, the extent to which you want to push that forward, and the extent to which you succeed in doing so. So as Tom was saying earlier, you really do have a huge say in what your practice looks like. And as he was explaining, well, he does a lot of claimant-based work, but of course, a lot of other people will do respondent work or defendant work, where actually the work is somewhat different to a certain extent, but it's something that you do have a say in driving forward. So it really does depend on what you're interested in doing, what work is available, what you end up succeeding in and getting repeat instructions on, and how your practice ends up evolving over time. So I think we are nearly there with the questions. I'm just going to scan through and see if there's anything that I missed. And if there is anything that you think that you need to ask still, you literally have a minute or two to do so, because we are keen to make sure that we don't overrun too much, and we will be drawing the evening to a close fairly soon. Hopefully, at the end of the day, what we're really keen to make sure that is clear to everyone is that we are a set that does a huge variety of work, as you've seen. Last year at an event very similar to this, the recording of which is also on our YouTube channel, we talked about the different practice areas in chambers, and as we can see from, and as I can see certainly from the questions that I've been asked, there's a lot of questions about different practice areas, whether or not you need to have experience in all of them. And the very simple answer, as I said earlier, is no. But we are keen for people to demonstrate to us that they're interested in a varied pupillage and a varied junior practice. And of course, how and when you specialise really does depend on you. So as Max said, he's enjoying the fact that he's doing lots of different types of work at present, and he's not sure at what point he does want to specialise, and that's completely fine. Equally, if you come in and you're interested in a particular area, or you develop an interest in a particular area over a short period of time, that's completely fine too, and it's something that we try and accommodate to the extent that we can. So just before we draw to a close, Marcia, perhaps I can ask you this, and Max, I'm going to ask you the same question in a moment. A very interesting question has come through. What's the best thing about life at the bar, and what's the worst?
Quickly span through 30 years. What's the best thing? I think the best thing is the varied day you have every day. Every day is different, and every day you also meet fascinating people, and every day you learn something new. You know, you always learn something new every time you go to court. It could be tiny, it could be big. And colleagues who are usually very supportive. The bar is a very supportive place. That's the best thing. The worst thing is not being able to go out on a Tuesday or Wednesday night because you get stuck in meetings and your friends hate you because you make a plan and then you cancel. And you need a lot of stamina, particularly if you have a court-based practice. You need a lot of stamina. And sometimes it can be very lonely. And that's why it's so good to have good colleagues, and so important to have good colleagues around you.
Absolutely. Thanks, Marcia. Max, a very different end of the career spectrum. What at present do you think is the best thing and the worst thing about life at the bar?
I'll start with the worst, because Marcia has just nicked the answer that I was going to go for, so I'm just going to repeat it, and let's end on a positive. I think the worst thing is you really are, even at my early stage, you do feel, well, I feel very self-employed, and that can, I do see how that could lead to it feeling like quite a lonely career, having worked in office environments and as part of teams. And that is why I'm really grateful that this is the chambers I'm at, because I do feel like I feel a collegiate with sort of atmosphere with other members of chambers, and I do have people that I'm constantly bouncing ideas off and coming into chambers and seeing and so on. So I really am grateful for that. In terms of the best thing, I think it is a career that demands the best of you every day, which is really challenging and means the learning curve is incredibly steep, certainly in your first few months, as I'm experiencing. And that's amazing if you want to challenge yourself and sort of give as much as you can to your career, then you'll see a lot coming out of it. So I think that's probably the best thing.
Fantastic. Thank you so much. Thank you to all of you for joining us. It's been really interesting to hear your questions, and hopefully we've been able to answer your questions as well. There's lots of information on our website that you might find useful. So there is a separate dedicated pupillage page where you'll see all the information about applying to chambers. There's also a mini pupillage page. There's also pages in relation to all the other particular outreach events that we do. So please do have a look at those if they are helpful to you. And thank you very much. I think somebody, our marketing manager, has put the link to the pupillage page into the chat box, so hopefully you can see that. So please do have a look through that, and if anyone does have any other questions, then please do get in touch. We wish you a pleasant evening, and we look forward to reading your applications in due course. Thank you very much.